Greetings everyone, we are students from Faculty of Law and International Relations.
For our assignment in Evidence and Procedure in the Shariah Court, we have prepared an interactive video to explain the criminal trial process in the Shariah Court.
In this video, we'll go through a set of questions together and each answer will be checked by our host who will explain whether we were right or wrong.
We hope this video will help all of us understand this important topic better and make studying more interesting.
Are you ready?
Okay, first question guys. When an accused is brought before the Shariah Court, what must happen first? A. The accused is sent to prison. B. The accused is asked to present his evidence. C. The charge is read and explained to the accused. And D. Witness statements are read out loud.
I think konfirmasi sebab kena baca tuduhan dulu kan sebelum apa-apa.
Betul tu, takkan tiba-tiba suruh dia bela diri tanpa dia faham dia punya kesalahan kan?
Correct. Under Section 96 subsection A, the first step when an accused appears in the Shariah Court is that the charge must be framed, read and clearly explained to the accused. This is absolutely crucial because it ensures that the accused understands of what offence they are charged with, the nature of the charge and their right to either plead guilty or claim the trial. Without reading and explaining the charge, it would be unjust. A fair trial with knowingly exact what one accused of.
See? Basic sangat benda ni tapi pentinglah untuk kita elak salah faham dekat dalam court.
Soalan nombor 2. If the accused pleads guilty, what must the judge ensure before convicting? A. The accused must pay a fine. B. The accused give a written confession. C. The accused understand the nature and consequences of the plea. And D. The accused does not request a lawyer.
Aku rasa macam B, mesti kena tulis pengakuan tu kan?
Betul? Aku rasa B, kena ada hitam putih kan dalam mahkamah.
Wrong. The answer is C, because the judge needs to make sure that the accused understand the nature and the consequences of their plea. So under Section 96 Clause P of the Shariah Criminal Procedure Federal Territories Act 1937, a guilty plea is not simply an admission. It can result in severe consequences like imprisonment, fines and even whip. So that is why judges need to confirm the accused fully understand what they are admitted to and the implications of their plea. This is to protect accused from being tricked, coerced and pleading guilty without knowing their rights.
Nasib baik ada explanation. Serius, kalau tak faham betul-betul boleh habis masa depan.
Okay, third question. If after prosecution's evidence there is no case against the accused, what should the court do? A. Remand the accused. B. Record an order of acquittal. C. Ask the accused to give his evidence, his defense. D. Refer the case to the chief Shariah prosecutor.
Yang ni aku rasa B, kalau tak ada bukti mestilah bebas.
Correct. According to Section 96F, if the prosecution's evidence fails to establish a prima facie case, the judge must record an order of acquittal. This principle is crucial since it upholds the legal standard that the burden of proof rests on the prosecution. If they cannot prove the case, the accused should not be forced to defend themselves unnecessarily. It ensures the presumption of innocence and prevents wrongful convictions.
Betul lah. Mana boleh paksa orang bela diri kalau pendakwaan sendiri tak ada case against the accused.
Okay, soalan keempat pula. Who has the right to cross-examine prosecution witnesses? A. The judge only. B. Religious enforcement officer. C. The accused or his peguam syar'i. D. The public prosecutor from civil court.
Kita jawab C lah. Memang tugas peguam tertuduh soal balas.
Correct. Under Section 96 subsection E, the right to cross-examine prosecution witnesses is given to the accused or their peguam syar'i. Cross-examination is a vital part of the fair trial. It allows defense to test reliability of the prosecution's witness, uncover contradiction or expose falsehood. Without cross-examination, trial would be unfair and one-sided.
Kena ada cross-exam lah. Kalau tak, macam main tuduh je diorang ni.
Okay, the fifth question. Can the judge amend the charge during trial? A. Yes, before the judgment is given. B. No, once the charge is read, it cannot be changed. C. Yes, but only with approval from the Mufti. D. No, only the Chief Sharia Judge can amend it.
Aku rasa B lah. Mana boleh ubah kalau dah bacakan charge?
That incorrect. The correct answer is A. Yes, the judge can amend or add to the charge anytime before judgment under Section 83. The power to amend charges allows the judge to ensure the charge matches the facts proven in court. For example, if new evidence shows the offence is different from what was initially charged, the judge can amend it so the trial proceeds on the correct legal basis. But the accused must be informed of the charges.
Oh, rupanya boleh ubah. Tapi mesti bagi tahu accused lah. Sebab dia punya rights kan. Faham?
Okay, before we continue with further questions, let's just take a short break and take a look at something important. How does a Sharia criminal trial actually begin? According to Section 72, there are actually 3 ways. First, if someone makes a complaint about a crime and the judge decides it's serious enough, the trial can start. Second, if the judge sees the crime happen with his own eyes, like if he personally witnesses it, he can start the trial. But if this happens, the accused has the right to object and ask for a different judge because it might not be fair for the judge to become a witness also. And third, if the accused is brought to the judge without a warrant, for example, if caught committing the crime, the trial can also begin immediately. So now we know trials don't just randomly start. There are clear legal steps under Section 72. Alright, now let's get back to the quiz.
Soalan nombor 6. Under what condition can multiple offences be tried together? If A, if they are of different kinds. B, if they are of the same kind within 12 months. C, only if approved by the police. Or D, the accused confesses.
Okay, kita jawab B, sama jenis dalam 12 bulan.
Correct. Section 89 allow multiple offences of the same kind committed within 12 months to be combined and be tried together. So this provision is practically because it avoids having to conduct separate trials for repeated similar offences, which save time and also judicial resources. But it only applies to offences of the same kind. Different offences must usually be tried separately.
Makes sense. Kalau kes sama banyak kali, better trial sekali je.
Alright. 7th question. When must evidence be taken in the presence of the accused? A. Always. B. Only if the judge allows. C. In all trials according to Section 111. And D. Only if the witness requests it.
Aku rasa hakim yang decide.
That's not correct. The correct answer is C. In all trials, evidence must be taken in presence of the accused according to Section 111. This guarantees the accused's rights to hear, understand and respond to every piece of evidence presented against them. It's a cornerstone of open justice. The accused cannot be convicted based on evidence they never heard.
Oh yelah, pentingnya kehadiran accused masa bukti kena bentang. Kalau tak ter-exercise lah right of accused to fair trial. Kan?
Soalan nombor 8. What happens if the complainant is absent on the day of the trial? A. The judge must postpone the trial. B. The judge may discharge the accused. C. The accused is automatically convicted. Or D. The prosecutors take over.
Kita jawab A, mestilah dia akan tangguh.
Wrong. The answer is B, because the court may discharge the accused under Section 96 clause and if the complainant is absent. So this provision prevents misuse of judicial process. If the complainant doesn't show up, it could mean that the case has no merit or complainant is not serious, so the accused shouldn't have to wait indefinitely.
Bagus juga, tak adalah tertuduh tunggu komplainan yang tak nak committed.
Okay, soalan ke-9. When is a person considered to be convicted? A. After police investigation. B. After court finds them guilty or accepts a guilty plea. C. When the public agrees. D. After mufti's decision.
Aku rasa B. Sebab polis mana boleh nak sabitkan.
Correct. A person is only convicted after the court finds them guilty or accepts the guilty plea. As stated in section 96, subsection M, until then, they are presumed innocent. That's a fundamental right in criminal law. This means the police investigation alone cannot be labelled someone a criminal. Only the judge has the legal power to convict.
Patutlah ada kata innocent and proven guilty. Law regulated to protect the fundamental rights of the people and to protect the public interest too.
Okay, final question dari set asal. Who can defend the accused in a Sharia criminal trial? A. A civil lawyer. B. A peguam syar'i. C. A family member. Or D. No one. Self-representation only.
Senang je. Aku confirm jawapan dia B.
Yes, that is correct. Under Section 1 of 4, the accused has the right to be defended by peguam syar'i, a lawyer specifically qualified to practice in the Shariah Court. So this to ensure a proper representation that understand both law and Islamic principles apply in Shariah proceeding.
Kalau peguam biasa, dia tak boleh wakil dekat Syariah Court kan?
Hold on. We've talked about trials, but what happens after someone is found guilty? Let's go through how the court gives punishment in a Sharia case. The court can give different punishments like imprisonment, fines, or even whipping, but each has rules. For jail sentences, the court issues a warrant and the person is taken to prison. For fines, the court can allow time to pay, allow installments, or order the seizure of property if they don't pay. If they still don't pay, they can be jailed instead. For whipping on the other hand, a government doctor must check if the person is healthy enough, and special rules control how the whipping is done to avoid unnecessary harm. And for young people or first-time offenders, the judge can release them with a warning or a bond for good behavior instead of punishment. So, sentencing in Sharia Court isn't just jail or fine. It's guided by proper procedures and even considers the age, health, and background of the accused. Now, let's continue. Bonus question. What must happen if the charge is amended during trial? A. Accused must plead to the amended charge. B. Trial is cancelled. C. Judge must resign. D. Case is sent to the civil court.
Aku rasa A lah. The accused must plead to the amended charge.
Correct. According to Section 84, whenever charge is amended, the amended charge must be read and explained again to the accused, and they must be asked to plead. This gives the accused a fair chance to know the updated charge and decide their.
That's logic. Kalau tak nanti accused blur lah pasal petuduhan baru tu. Or in other words, might just happen dia tak faham the nature and consequence of it. So boleh jadi salah kalau jatuh verdict when dia tak aware of what he has been charged with.
Soalan seterusnya, when the judge finds the accused not guilty, what must be recorded? A. An order of acquittal. B. An order of remand. C. An order of postponement. Or D. An order to re-investigate.
Jawapannya mestilah A.
Correct. Section 96M I requires the judge to record an order of acquittal if the accused is found not guilty. This order formally ends the case and releases the accused from the charge. It's an essential document to protect the rights of someone proven innocent.
Senang faham. Kalau tak salah terus bebas dengan record je lah. Okay, just before we head into the last few questions, let's understand what happens after the trial ends on the judgment and right to appeal. Judgment must be given openly in court so that everyone can hear if the judge delays it, and they have to tell when the judgment will be delivered. And the judge must also explain the judgment clearly to the accused, and if the accused asks, he can get a written copy for free after the judgment. Everything must be recorded and kept safely in the case file. If someone is not happy with the decision, they can appeal to the higher court, but they must do it on time. They have to file a notice of appeal within 14 days and then submit reason for the appeal within 10 days after getting the judgment written reason. If they miss the deadlines, the appeal will be cancelled, but the court can extend time if there is a good reason. See, the Sharia system gives people not just a fair trial but also a fair chance to appeal. Alright, quiz time again!
Okay, next. 13. Who decides which Sharia court will try an offence if there's doubt? A. Mufti, B. Chief Sharia Judge, C. Accused family, D. The police.
Aku rasa jawapan dia mesti B.
Correct. Under Section 71, if it is uncertain which Sharia court has jurisdiction, the Chief Sharia Judge decides which court will hear the case. This ensures clarity and avoids multiple courts hearing the same case, which prevents conflicting judgments.
Oh, baguslah ada chief yang boleh settle this matter of things.
Okay, soalan ni pula. How must the judgment be delivered? A. By email, B. Secretly, C. Openly in court, or D. Through the police?
Kita jawab C lah, mesti terbuka.
Correct. According to Section 118, the judgment must be pronounced openly in the court so that it's transparent to the both parties and the public, prevents secret or unfair decision. This open delivery upholds the trust in the justice system.
Scary-nya kalau jatuh hukum senyap-senyap.
Alright, last question. Okay, last question. Who can take cognizance of offences in Sharia court? A. Religious enforcement officer, B. Judge, C. Peguam syar'i, D. The public prosecutor.
Aku rasa kita jawab B.
Yay! That is correct. Section 72 gives authority to the judge to take cognizance of offences, whether by receiving complaint, having knowledge of the offences himself, or when someone is brought before him accused of committing an offence. So this power allows the judge to formally start judicial process.
Bagus. Power ni bagi mahkamah mula kes bila perlu. Different from criminal court biasa where cases can only be brought up or prosecuted in the discretion of public prosecutor. Alhamdulillah, we've completed all 15 questions.
So, we have learned so much like the rights of the accused, the judge's power, and important procedures like amending the charges.
I hope our sharing doesn't just help us revise but also benefits everyone who's watching.
Understanding this process is crucial to ensure justice is upheld in the Sharia court.
So, thank you for watching our video. Bye-bye.